Hello everyone. I hope you've been very well. I'm Taniya Pandey, welcoming you to courts this week at LiveLaw and bringing to you the important judgments of the week. In a rather extraordinary move by the Supreme Court, a judgment of the Nagpur bench of the Bombay High Court, which held that skin-to-skin contact is necessary for sexual assault under the POCSO Act, was stayed on January 27th on a mention of the case by Attorney General Mr. K.K. Venugopal. CJI Bobde has directed the Attorney General to file a proper petition challenging the judgment. The single bench of Justice Pushpa Ganediwala had acquitted a 39-year-old man accused of sexual assault for groping a 12-year-old girl and removing her salwar, and had held that pressing of breasts of a minor girl without disrobing does not amount to sexual assault within the meaning of Section 8 of the POCSO Act. Comedian Kunal Kamra, in his response to the Supreme Court contempt notice, has said, and I quote, "Suggestion that my tweets shake foundation of the most powerful court is an overestimation of my abilities." A bench of Justices Ashok Bhushan, R. Subhash Reddy and M. R. Shah had issued notice to Kamra on December 18 on the petition seeking criminal contempt action against him for his tweets against the judiciary. The Madhya Pradesh High Court, Indore bench, dismissed bail applications filed by comedian Munawar Farooqi and co-accused Nalin Yadav, who were arrested on January 2nd for allegedly hurting religious sentiments during their comic show. A single bench of Justice Rohit Arya said that it was not commenting on the merits of the case as investigation was under progress, but the materials collected so far suggested prima facie commission of the offence. Supreme Court has issued directions for virtual recording of testimonies of child victims or witnesses of human trafficking who are required to depose in courts which are far away from their place of residence and may be in a different state. A bench of Justices L. Nageshwar Rao, Abdul Nazir and Indu Malhotra had taken suo motu cognizance of the case and passed specific directions regarding the manner in which evidence would be recorded. The Supreme Court has set aside a Karnataka High Court order and granted bail to Kannada actor Ragini Dwivedi, who had been arrested by the police for allegedly consuming and supplying drugs at parties and events organized by her and others. The court noted that firstly, no drugs had been found with the petitioner Ragini Dwivedi, and the entirety of the case against her was based on a statement. Second, it could only be assumed that she had consumed drugs at the parties, and thirdly, it was important to note that she had also been arrested on a conspiracy charge, which the High Court had itself found to be tenuous and had said nothing about it. Supreme Court has observed that a High Court, while exercising bail jurisdiction, cannot issue directions which will have a direct bearing upon the trial. In this case, persons accused of murder had approached the High Court seeking bail. They had contended before the High Court that a CCTV footage would prove their innocence. The Bombay High Court bench at Aurangabad directed the investigating officer to examine a CCTV footage and to submit a report. The Supreme Court observed that when only the limited issue of grant of regular bail to the accused was pending consideration before the High Court, it was not appropriate for the High Court to have passed the directions which would have a direct bearing upon the trial. The Supreme Court set aside concurrent conviction in a murder case after it found that the accused was a juvenile, 17 years and 1 month old, on the date of the incident in the year 1983. The trial court judgment convicting Yogendra Yadav in a murder case was upheld by the Allahabad High Court in 2019 by dismissing the appeal he had filed in the year 1985. The Supreme Court has observed that successive anticipatory bail applications ought not to be entertained. The first and second anticipatory bail applications moved by the accused were dismissed by the High Court. The third bail application was allowed, observing that 6 months had passed from the date of dismissal of the earlier anticipatory bail application. The court had also taken note of the fact that accused was aged 69 years. In appeal, the bench comprising Justices A.M. Khanvilkar, B.R. Gavai and Krishna Murari disagreed with the High Court's approach of granting bail and observed that the specious reason of change in circumstances cannot be invoked for successive anticipatory bail applications once it is rejected by a speaking order, and that too by the same judge. The Supreme Court has upheld the Madhya Pradesh High Court's order dismissing the anticipatory bail application filed by an accused who was charged under relevant provisions of IPC, Medical Termination of Pregnancy Act 1971 and PNDT Act 1994 for allegedly conducting illegal medical practices of sex determination and sex-selective abortion. The bench of Justices M. Shantanu Gowda, Vineet Saran and Ajay Rastogi, while dismissing the appeal, observed that a strict approach has to be adopted if we are to eliminate the scourge of female feticide and inequity towards girl children from our society. Deprivation of property right can only be in accordance with the procedure established by law, the Supreme Court reiterated while considering a case involving proceedings under Madhya Pradesh Sealing on Agricultural Holdings Act 1960. The dispute was regarding the appellant's land, which had been declared as surplus and was being taken over by the respondents. The bench of Justices Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy observed that the provisions of the Act had to be complied with to deprive a person of the land being surplus. Supreme Court has directed the Delhi University to declare the 5th semester result of a law student who could not meet the requisite 70% attendance criterion due to her pregnancy. The petitioner, Ankita Meena, had approached the Delhi High Court seeking a direction to the university to permit her to appear in the 4th semester LLB examination. The High Court had refused to grant her any relief. In appeal, the Supreme Court passed various interim orders which enabled her to attend the examinations of the 4th, 5th and 6th semesters. The Supreme Court has held that dismissal of a petition for transfer may not operate as res judicata when a fresh petition is filed on change of circumstances. A woman's transfer application in a family suit had been dismissed in the year 2016. She moved the Apex Court a second time, seeking the same relief on the ground that there are change of circumstances. Mutation entries do not by themselves confer title, the bench comprising Justices D.Y. Chandrachud, Indira Banerjee and Sanjeev Khanna has observed. In this case, a title suit between the petitioner and a charitable trust was pending adjudication. The Karnataka High Court, however, issued a direction for mutation which was challenged by the petitioner before the Supreme Court. The Apex Court, while disposing of the SLP, observed that it is well settled that mutation entries do not by themselves confer title which has to be established independently in a declaratory suit. In the context of the 2013 Supreme Court rules, the Supreme Court left it to the rule-making authorities to examine whether they would like to expand the registration of advocates on record to permit persons to carry on the profession in the style and name of a sole proprietorship firm. The bench of Justices S.K. Kaul, Dinesh Maheshwari and Rishikesh Roy said, and I quote, "The Supreme Court rules being sacrosanct, we would not like to interfere with the same in the present proceedings." The Supreme Court has modified a direction issued by it in the matter of constitution of a search cum selection committee for appointment of members of the tribunals. The Attorney General submitted that there are 19 tribunals and that it would be difficult for the Secretary of the Ministry of Law and Justice to act as a member of every search cum selection committee and that it might hinder with his other duties. The court accordingly allowed the centre's request for the substitution. A statute must be interpreted in a just, reasonable and sensible manner, the Supreme Court observed while dismissing a special leave petition against the Rajasthan High Court judgment. It was contended in the SLP that a single transaction of purchase of a motor vehicle does not bring a person within the definition of casual trader under Rajasthan Tax on Entry of Motor Vehicle into Local Areas Act 1988. The bench of Justices Indira Banerjee and Sanjeev Khanna noted that the definition of casual trader in the Act makes it clear that a person with occasional transactions of buying or selling are to be treated as casual traders. The Supreme Court has reiterated that once possession is taken by the state, the land vests absolutely with the state and the title of the landowner ceases. The High Court had nullified the original award and allowed fresh acquisition proceedings in respect of the first respondent's land, which had already been acquired and had been under the possession of the appellant since June 2010. The basic philosophy inherent in granting the power to the Supreme Court to review its judgment under Article 137 is a universal acceptance of human fallibility, the Supreme Court observed in an order allowing a review petition. The bench comprising Justices Ashok Bhushan and Indu Malhotra observed that the rejection of miscellaneous application seeking recall of a judgment does not preclude filing of a review petition subsequently. The Supreme Court has set aside an Allahabad High Court judgment which quashed appointment of an assistant professor. The bench comprising Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah noted the provisions of the King George Medical University Act regarding the time limit for submitting representation and observed that appointment of the appellant had not been challenged within reasonable time as per provisions of the Act. The Supreme Court has observed that an appellate court's jurisdiction under Section 96 of the Code of Civil Procedure involves a rehearing of appeal on questions of law as well as fact. The Karnataka High Court had dismissed the appeal filed against a trial court judgment in relation with a petition under Section 278 of the Indian Succession Act, praying for issuance of a letter of administration in respect of a will. A bench of Justices S. Abdul Nazir and Suryakant, while setting aside the High Court's order, observed that all questions of fact and law decided by the trial court are open for reconsideration at the appellate stage. Those were the top stories of the week. Don't forget to like and share this video. I hope you've had a lovely weekend. I'll see you again very soon.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.